Hello, welcome to our webinar on investments for charities. I'm Nicola Morriss, I'm a legal director in the Burkitt's Charities team, and I'm joined today by my colleague Jess Caws, who is a legal director in our corporate department, and she's co-head of our financial services team. The plan for today is to do a preliminary introduction and talk you through the different sorts of investments there are for charities. So social investments, we'll dabble over that quite quickly, and financial investments. And then we'll spend a little bit of time talking about the different financial investments that there might be, that you might be interested in making. And towards the very end, we'll give you some practical considerations to think about. Just to start, we thought it would be interesting for you to have a look at different investment terminology that there is that you might have come across. Now, on this slide, you'll see a number of different terms that people use when they're talking about investments. Some of these are quite old terms and have been replaced, but you still might come across them, and it can be really quite confusing. What do they mean? As a trustee, what should you be thinking about? Are they different? Are they the same? Are there nuances? Where do you start? It can be really confusing. So what we hope to do with this webinar is to help you to make a little bit more sense of the terms that you come across and to understand what you are actually investing in, and what considerations you need to take into account when you're making an investment on behalf of your charity. So what types of investments are there? Essentially, there are two. There are financial investments and there are social investments. Now, what we're not going to do on this slide, in this webinar, is we're not going to talk about the power to invest and trustee duties. You do need to think about that when you're thinking about investments, but that's not something we're going to be focusing on here. Suffice to say, most charities will have a power to invest either in their governing document or in statute, and broadly that will give the trustees the power to make an investment unless it's prohibited. So if you have a prohibition in your governing document, then you really do need to have a look at that and see what you are permitted to do. In terms of duties of trustees, again, these will be set out in your governing document and in statute. There is a duty of care that you need to be aware of. You will need to be considering different suitabilities and diversification of investments. You'll need to take professional advice and you need to review them at different stages. But as I say, that's a very, very high level view of powers and duties, and we're not going to talk about those anymore. We're going to focus much more on the types of investments that charities can make. Now, as I say, there are broadly two: financial investments and social investments. And under charity law, these two have very specific meanings. So let's have a look first at social investments. This has a specific definition in the Charities Act 2011, and that was introduced by the 2016 Charities Protection and Social Investment Act. Now, you may have heard and you may have seen on the previous slide mixed motive investments and program-related investments. Now, those are rather older terms for what we now call a social investment. What a social investment is written on the slide there, a relevant act which is defined within the Act, and that is with a view to both directly furthering the charity's purposes and achieving a financial return. So you'll see that there's two limbs to the test here. The first is that you are furthering the charity's purposes, and that is one of the points of the investment. You are making it with the aim of furthering your charity's purposes. But in addition, there should be a financial gain element. Now, what's interesting about social investments is that the financial return can simply be receiving back your initial capital investment. There is no need for it to be any more than that. So there's no need for you to have made any interest on that investment or for there to be anything more than just a recovery of your initial capital investment. Now, sometimes confusion can arise when we are talking about social investments, but we don't mean a social investment in this form. What we're talking about rather is a financial investment, but we use the term social investment to talk about that. Usually this comes under the ESG form of financial investment, and we're going to talk about that much more. But the reason I've included this slide is just to make it very clear for you that you need to understand what investment you are making. Is it a social one or is it a financial one? So let's talk more about financial investments, and this is where we're going to focus our slides on for the rest of the webinar. What is a financial investment? Well, helpfully, there's no statutory definition. The Charity Commission guidance used to say that it was an outlay of funds in something which it is hoped will lead to a financial return. That's now been slightly more clarified in view of case law, more recently the 2022 case, which we're going to talk about in a moment, but it reflects case law much more clearly now. The Charity Commission guidance explains that a financial investment is one with the ultimate object of making money by one or both of the following: either generating income or increasing the value of the investment through capital growth. And you'll see that that does much more reflect the Harries case from 1992, that the trustees are using charity property for the purpose of generating money, whether that is income or capital growth. So that is what we mean by a financial investment. So what qualifies as an investment? Well, various different things do. You can either put your cash on deposit, that's an investment if you're receiving a return. You can invest in shares. Loans qualify as an investment, investing in a trading subsidiary, which a number of charities will do, particularly the larger ones. CAIFs, which we're going to come on and talk about in a little bit. Hedge funds, commodities, derivatives, these are all investments. What does not qualify as an investment is the social investments I referred to earlier. Those are not financial investments. And also donor advised funds. Now, this can be quite confusing for some people, because a DAF, as they are known, they are often used by charities or individuals to make an initial donation to an organisation where the money is then invested. So it feels like an investment. But what's really important to understand is that the original donation that is being made to the organisation is a charitable donation. It works as a charitable gift. So as soon as it is made and it leaves the charity or the individual, it functions as the charitable donation, and it now becomes an asset of the organisation who receives the money. What they then do is they will invest that money for you, and they will then operate on your advice or on the charity's advice, and they will make further donations to different charities. So that's why it's known as a donor advised fund. You make the donation and then onward donations are made under advisement. But it's important to know that when the original donation is made, the charity essentially does lose control over that money, or the individual making the donation. So if they wanted to, the recipient of that donation could then apply it however they wish. Generally they don't. They follow the advice of the person who's made the initial donation, but it is no longer their asset. So all of that to say, DAFs are not investments, and that's really important just to recognise that. Another thing which I'm going to repeat in a little bit is that if it is not a true investment, then charities need to be very aware that this could qualify as trading, and there's of course tax implications to that. So it's important at the outset, when you're thinking about what investments to make, that you are happy that those investments are true investments. Now, on this slide, I just want to spend a little bit of time talking about the 2022 Butler-Sloss judgment. This was an important case in relation to charity investments. It was a first instance case, but the judge was really helpful in setting out what the considerations are that trustees should take into account when making financial investments. Now, the case was brought by two trusts who had an investment policy, and they'd proposed a new one where the new policy significantly limited the investment universe. And it was very likely that there was going to be a financial detriment to the charities in the short term. So what they had proposed was that they would only invest in companies which aligned with the Paris Agreement. And that excluded over half of all publicly traded companies and many commercially available investment funds. And they brought a case to the High Court to ask the judge essentially to rubber stamp their policy and say that it aligned with their duties as trustees. Now, the judge considered it, and he repeated the Harries case and explained that financial investments were the application of property by trustees for the purpose of generating money. So the starting point always is that you try and get the maximum financial return, which is then spent on the charity's purposes. But he did note that increasingly, charities want their investments not only to work for them financially, but they also want to achieve particular aims in terms of environmental or social issues, and they also might want to align with their stakeholders' views on those issues. So there's more to consider. And the judge helpfully, at paragraph 78, if you're interested in having a look, he helpfully set out lots of considerations for the trustees. Essentially, it comes down to this, and it's a restatement of the law. If the investment is prohibited within the governing document, the trustees cannot make it. So that's point number one. However, if there's no prohibition, which is likely to be the case for the vast majority of charities, then the trustees ultimately have discretion, and they have the power to make a financial investment, even if that investment would contradict or conflict with their purposes. If, however, investment does potentially conflict, then they have to balance all of the factors, including the financial effect, the seriousness or likelihood of the conflict, the potential loss of support from donors, reputational damage to the charities, if they were to continue with an investment which was not a green one, which conflicted with their purposes. And they have to justify their reasoning as to whether they ultimately decide to or not to make that sort of an investment, provided they act reasonably and honestly. So there's the duty of care coming in, and they've balanced everything. It's a decision for the trustees, and it will generally be taken as one within which a reasonable body of trustees can take, and that it'll be highly unlikely that it will be criticised. So it's a balancing exercise, ultimately, one for the trustees' discretion. So let's have a little bit more of a look at these financial ESG investments, in case that's something that you are interested in looking into in a bit more detail. Again, there's some terminology here. They're not always called ESG. They might be called social or moral or ethical or sustainable investments. There is nuance to these terms. So what is important is that you understand what it is that you mean. And when you're talking about it as a board and with your investment managers, that you're using terminology that you all understand and that you're very clear on. So thinking about ESG investments as a charity, what exactly are these? And if you're interested in making them, what do you need to be thinking about? Well, the ESG, as I'm sure you're aware, stands for environmental, social and governance investments. And these are financial instruments. So the social there does not refer to the social investment that we talked about earlier, the specific definition under the Charities Act. If you're thinking about making a social investment, that would generally be a loan to an organisation which is achieving a social mission. So the financial return would be part of the investment, and the social element would be the social mission that that organisation is hoping to achieve. Often ESG investments are part of a fund, and I'm going to bring my colleague Jess in now, because this is very much her area of specialism, just to talk a little bit more about how ESG investments form part of a fund and what considerations there are from a financial regulatory perspective in relation to those.
Thank you, Nicola. So I just wanted to speak a little bit first about what ESG means in the context of financial services. So you were speaking a little bit about social from a sort of charity law perspective, but I wanted to pick that up in the context of financial services law. So it tends to be with financial services that there is a focus on the E in the ESG. And that is because I suppose that environmental elements are a bit more easy to sort of benchmark and regulate, whereas the S, the social element, is perhaps harder to sort of put in sort of written legislation. So there have been some measures to deal with the sort of S element from a financial services perspective. For example, there was sort of a recent requirement for the boards of listed companies to make more disclosures around diversity and inclusion, for example, around the composition of their board, and that is sort of aimed to deal with this sort of S in the ESG for people who wish to invest in listed companies. There were sort of proposals to roll those D&I elements out across financial services businesses as a whole, but that unfortunately has been dropped this year. So we will not see that sort of in its current iteration happening at the moment. What the FCA has chosen to focus on, however, is sort of improving culture in financial services businesses. So this concept of what they call removing bad apples who sort of reappear at different financial services businesses with no sort of issues. They are trying to introduce a new rule which will come into force in September next year, which will mean that non-financial misconduct within financial services businesses will be in scope of what we call conduct rules that apply to senior managers and certain key staff within those businesses. So things like bullying or violent conduct, if that's within the scope of the regulated activities of the firm, will be something that HR or people considering those assessments can bear in mind when they're looking at whether someone has breached one of these conduct rules. So you can see that there are some sort of internal measures rather than disclosure measures in terms of financial services businesses, which arguably might have more impact. But moving on to the fund side of things, I wanted to speak about the FCA's rules relating to green funds, which we call the UK Sustainability Disclosure Requirements. So to start with, the FCA has introduced a general anti-greenwashing rule, and that applies to all firms. It came into force in May last year, and really it means that firms who are regulated by the FCA are not able to make sustainability related claims unless they are fair, clear, and not misleading. We also have a sort of second package of measures under the sort of banner of the SDR. The first is that asset managers have a sort of package of sustainability labels that they are able to attach to their funds if they wish to do so. But they must comply with certain criteria to attach the label. The labels are sustainability focus, sustainability improver, sustainability impact, and mixed goals as to sustainability. So, for example, with the sustainability focus label, which I believe is sort of the most difficult one to achieve, 70% of the asset value within that fund must be aligned with the sustainability objective. So it's quite difficult to sort of do that and also ensure you are sort of getting those returns that you need for your investors to make them want to invest in the fund in the first place. So my understanding is that the labels have not been all that popular because it is just quite tricky to comply with the thresholds. Separate to that, there are also naming and marketing rules relating to ESG related terms for investment funds. This is really to prevent the use of misleading language in addition to those sort of labels. So asset managers cannot use terms like sustainable or ESG, things like that, unless they can really sort of substantiate those terms and explain why they're being used in the context of that fund. So that's sort of a more general rule, but only in relation to investment funds, separate to the general anti-greenwashing rule that applies to all firms. There are also specific investor disclosures that need to be made regarding sustainability before investment is made and also on an ongoing basis. The FCA was consulting on what we call a green taxonomy, which is sort of a codified way of explaining which economic activities are sort of sustainable and which are not, and sort of ranking them effectively. And this was sort of planned to be put in place so we could sort of work out which investments were environmentally sustainable or better from a sort of ESG perspective. And this was based on the EU green taxonomy. As I said, the FCA has abandoned this, mostly I think because it's moving towards a principles-based regulation approach, whereas the EU has traditionally sort of been very granular in what they regulate. So there's definitely sort of a regulatory mismatch developing, particularly on the sort of ESG related green financial instruments side. So if you have an asset manager, for example, who wants to market a green fund in both the UK and across the EU, there's going to be completely different requirements in each sort of jurisdiction, even though they're quite similar, which is quite tricky. I also wanted to speak about charity authorised investment funds, otherwise known as CAIFs. So these are a type of fund that are authorised by the FCA, so the fund itself is authorised. They are also registered as a charity, so there's sort of that dual prong regulation. So from sort of Nicola's perspective, my understanding is that these are described as a financial investment rather than a social investment. And CAIFs are very much long-term investments for charities. Generally, they are going to invest in companies or limited partnerships, and these will have a long sort of requirement as to making sure you get a return. So charities should assume sort of an investment period of 5 to 7 years or even longer, really. They're attractive to charities because I understand that they mean that charities can claim certain tax reliefs. CAIFs also have what is called an income reserve account, which allows for smoothing of income distributions. And there's also a possibility to avoid VAT on management fees, which makes them attractive. CAIFs often have what we call an advisory committee. So I think one of the other things that makes them very attractive to charities is that they have this sort of robust governance structure. We have the FCA authorization, we have the charity registration, and then there's sort of these different sort of pillars of sort of independence around the fund itself, like an advisory committee. So, and the separate authorized manager. So they're seen as a very sort of sophisticated investment in that respect. Contrast these CAIFs with the old common investment fund. These were traditionally registered as a charity, but they had the oversight of the FCA in the sense that the manager of the Common Investment Fund was authorised, but not the Common Investment Fund itself. So we found that the Charity Commission was becoming very reluctant to approve new common investment funds. Where I used to work, we tried to set up a couple, and that just wasn't happening. So we had to approach things slightly differently. So it's definitely CAIF for the future, not the Common Investment Fund. Right, I think I'm now going to involve Nicola on discussing this next slide. So we just wanted to talk a little bit about the sort of practical considerations around making financial investments and things that charity trustees should think about when they wish to do so.
Thanks, Jess. Yeah, so initially, let's bring it right back to where we started. As charity trustees, you need to make sure that you have a power in your governing document, or that you're relying on under statute, and you need to be aware of what your trustee duties in relation to investments are. So do just check you do have a power and that there's no exclusions within your document. Once you've got that, you need to decide what sort of investment you're making. So under charity law, is it a social investment or is it a financial investment? And if it's a financial investment, what sort of investment within that are you hoping to make? Do you have an investment policy? You certainly should have one if you don't. And within that policy, have you written out your investment objectives? Have you set a risk profile? Do you have particular ambitions for your investments as a charity? Are they primarily environmental concerns? Is it social impact you're after? What exactly is it that you're hoping to achieve? So those are some preliminary charity focused questions, and then over to Jess for the rest of them.
Yeah, so if you're thinking of making an investment, there are a couple of things you need to think about. Obviously, firstly, what kind of investment are you thinking of making? Is it a CAIF, for example, that you're interested in, or are you going to sort of invest directly in some stocks and shares or bonds, things like that? As part of that, you may have an investment manager or investment advisor involved. And in which case they will be asking you things about your investment objectives, your risk profile. You're probably going to have to fill out sort of a detailed form setting out all these elements. I know another question is, have you carried out your due diligence, not only in relation to the investment, which is probably going to be more of a role for your advisor or manager if you have appointed one of those, but also on those advisors and managers, and are they sort of suitable people to be carrying on that role? And also, what's the relationship like with your investment manager? You should be engaging with them regularly. They should be providing you with detailed reports of any other investments that they are making for you, and sort of having a good discussion regularly about those investment objectives and your risk profile, making sure that everything remains suitable for the charity is very important. Same goes with sort of reviewing that relationship and the investment portfolio and discussing that with your advisor or manager. And moving on to the documentation that you might have in place. We would expect you to have an investment advisory agreement or investment management agreement in place with that person or organization. If you don't, definitely get in touch and make sure you do have one. Those agreements tend to be heavily regulated, so it can be quite helpful to have a lawyer have a look at that for you, just to make sure that there's nothing in there that is out of keeping with what you would expect under sort of an agreement of that type, just because of the type of client that charity would be for those entities. There would need to be a lot of sort of disclosure, regular reporting. You would have lots of rights pursuant to the regulatory rules. So we just need to make sure all of those are in there. The other thing is, yes, what investment documentation is involved in making the investment. So if you have appointed an investment manager rather than an investment advisor, they would largely deal with that on your behalf because they have discretion to invest your portfolio based on your objectives and risk profile. So they will really be sort of making choices on your behalf. But if you have an investment advisor instead, I'd say you'd be more actively involved in looking at the investment documentation. Under the role of an advisor, they'd normally, as it sounds, advise you to invest in something, explain why they advise you to do so, because it's suitable for your objectives and risk profile. But it is really for the charity trustees to make a decision as to whether they will then go ahead, and then they would need to have a look at the documentation. For example, if you're going to invest in a fund, that might be, as I said, a CAIF, or it could be something a bit more exciting, like a limited partnership. Particularly with a limited partnership, they will have very complex documentation around investing, and it's very important for a lawyer to have a look at those documents just to make sure there are no red flags that you haven't picked up. And red flags that you should be looking out for, I mean, in particular, things like indemnities that you might be providing to the counterparties. They're actually reasonably common in things like limited partnerships, but we as lawyers would need to make sure that they are not out of keeping with the sort of the market. And just that any clauses that require you to, or sorry, the charity to pay more than your sort of initial investment, or any rights, for example, for the manager or the fund to sort of claw back distributions or things like that. We'd need to just make sure that those are market standard, not unduly onerous, and also just so you understand the way that fees work and that, you know, that's clear to you what the charity is paying in relation to the investment. And that's probably it, really.
Jess, thank you so much. I'm well aware that it's been a bit of a canter through charity law and financial regulation in relation to investments. So if you do have any questions and you would like to get in touch with us, please do that. We're going to be sending a copy of the slides and the recording after the webinar, so that'll be circulated to you in the next few days. And details of both Jess and my details will be included within that. So you'll have our contact details should you want to get in touch. In the meantime, thank you for joining us. I hope it has been helpful, and I hope you have a lovely rest of your day.
Thank you.